और इन हालातों में इस एक्ट के बारे में बात करना बहुत ज़रूरी है, चूँकि कॉन्स्टिट्यूशन के ज़्यादातर एक्ट्स के बारे में हम तभी बात करते हैं जब वायलेशन होता है। जैसे फ्रीडम ऑफ स्पीच की भी हम जब बात करते हैं तभी हम बात करते हैं जब कोई वायलेशन हो, और प्लेसेस ऑफ वर्शिप एक्ट के साथ भी यही है। ज़्यादा वक्त मैं नहीं लूँगी, मैं कि हमारे स्पीकर्स के बारे में इंट्रोडक्शन देना ना देना ज़रूरी नहीं है, फिर भी उनके बारे में 2-3 लाइन मैं कहना चाहूँगी। मोहम्मद अफीफ जो हमारे साथ हैं, ये आइलाज से जुड़े हुए हैं और वो एक एडवोकेट हैं जो खासकर बेंगलोर और कर्नाटका हाई कोर्ट में काम करते रहे हैं। He has also represented PUCL, which is the People's Union for Civil Liberties, on behalf of sex workers, along with their colleagues Saida Sabha and Purna Ravi Shankar in the Karnataka Human Rights Commission. Prashant Bhushan is a prominent Indian public interest lawyer and activist who have been practicing in the Supreme Court of India since 1983. There are several public interest litigations that they have led, such as the 2G spectrum case, the coal block allocation case, the Rafale deal, and so on. They have written several books. The famous ones being the case that shook India, which was about the landmark Kesavananda Bharati case, My Tryst with Justice, which is his autobiography detailing their legal journey, and The State of the Nation, which was a collection of his writings on democracy and governance. Mr. Bhushan has been known for taking up cases which involve environmental protection, human rights, civil liberties, and corruption in high places. And his work has significantly influenced public discourse as well as academic discourse in eminent universities such as JNU and HCU and Jamia and so on. So I'll give over to our speakers.
So good evening, friends. मैं अंग्रेजी में बोलूं कि हिंदी में बोलूं? क्या आप लोग ज़्यादातर लोग क्या प्रेफर करेंगे? दोनों अच्छा। तो you have been told broadly what the Places of Worship Act is, and as you were told, it was brought in 1991 in the wake of this Ayodhya movement, just before the demolition of the Babri Masjid. And the act basically provides that there will be no change of a place of worship from its state in 1947, 15th August 1947, when India became independent. Whatever its status was at that time, it will remain the same. The only exception that they made was for the Ayodhya issue. That exception was made because suits regarding Ayodhya were pending, they were at an advanced stage of hearing, etc. And therefore that exception was made for the Ayodhya case. Now, Ayodhya case went on, and as you were told, it was finally decided recently by a judgment of a constitution bench of 5 judges, which included the then Chief Justice, Justice Ranjan Gogoi, who soon after the judgment retired and went on to become a Rajya Sabha member. It also included Justice Chandrachud. It also included Justice Nazir, who after retirement went on to become a governor. It also included Justice Ashok Bhushan, who after retirement was made chairman of the National Company Law Appellate Tribunal. Justice Chandrachud, of course, went on to become Chief Justice, and as you were told, so it is widely believed, ये सब मानते हैं, और दो उस जजमेंट में ये नहीं लिखा गया कि उस जजमेंट का ऑथर कौन है। नॉर्मली जब सुप्रीम कोर्ट कोई जजमेंट देता है तो जो जज, उस चाहे वो 5 ही जजेस का जजमेंट क्यों ना हो, पर जो जज उसको लिखता है उसका नाम ऊपर लिखा जाता है और उसके बाद बाकी 4 जजेस का दस्तखत होता है। अयोध्या वाले केस में एक ऐसा अजूबा केस जजमेंट था जिसमें ऑथर का नाम नहीं लिखा गया, लेकिन जिन लोगों ने वो जजमेंट पढ़ा उसकी लैंग्वेज पढ़ने से साफ समझ में आता था कि वो जस्टिस चंद्रचूड़ की लैंग्वेज थी। वही बहुत एरुडाइट जज थे, बहुत अच्छा लिखते थे और उन्होंने बहुत अच्छा जजमेंट, अच्छा मतलब कि लैंग्वेज बड़ी अच्छी है। जजमेंट तो बहुत बेहुदा है, क्योंकि जजमेंट में तो ये लिख दिया कि जिन लोगों ने मस्जिद तोड़ी, जिनको क्रिमिनल केसेस में प्रोसिक्यूट किया जा रहा है, उन्हीं लोगों को वो जमीन सौंप दी जाए मंदिर बनाने के लिए। ये क्लियर है कि ये एक पॉलिटिकल जजमेंट था और इसकी ड्राइविंग तो सरकार ही कर रही थी और इन लोगों ने मान लिया जो भी सरकार चाहती थी वो कर दिया। लेकिन उसी जजमेंट में 2-3 पेज इस पर लिखे गए कि ठीक है, चलिए ये अयोध्या में तो ये विवाद हो गया, वी हैव decided this Ayodhya judgment in some particular way, but in future such disputes will not arise because there is a Places of Worship Act, and because of that act having come, no such dispute about a place of worship can arise in future. ये लिख दिया गया और ये भी लिखा गया कि ये Places of Worship Act is a very important salutary act which has been brought to ensure that such disputes do not arise in future. लेकिन अनफॉर्चुनेटली उस जजमेंट के बाद जो हिंदुत्व फोर्सेस, आरएसएस, बीजेपी, बजरंग दल, विश्व हिंदू परिषद, ये सब जो ऑर्गेनाइजेशंस हैं, इन सब ने पहले तो ये अनाउंस किया कि नहीं, हम 2 और मस्जिद लेंगे, एक ज्ञानवापी जो कि बनारस में और एक मथुरा में, जिसको वो लोग बहुत अहम मानते थे। अब ज्ञानवापी में सूट फाइल किया गया। सूट क्या फाइल किया गया कि we should be permitted. Of course, basis of the suit was that this was earlier a temple which was broken down, or there was a temple in this place which was broken down and a mosque was made there. It's another matter that there is a temple right next to it, that Vishwanath Mandir. Yet, this claim was made that this mosque has been made by Aurangzeb after breaking a temple. And therefore the first thing that they wanted was a survey to be made of the place by the archaeological survey to find out whether there are signs of a temple in, around or below the mosque. This issue went up to the Supreme Court. And I was there in the Supreme Court when this issue was argued. And the lawyer who was appearing for the Muslim organization which had control and possession of that mosque, the Gyanvapi mosque, he argued that this suit itself cannot be allowed to go on because this suit is barred by the Places of Worship Act. If you cannot convert, and therefore he asked for stay of the suit. Now Chandrachud not only made an oral observation, So it's true that the observation that he made is not written in his judgment. It is an oral observation. He made an oral observation that the Places of Worship Act prevents the conversion of a place of worship from its character as it was in 1947, but does not bar an investigation as to whether there was a temple below that mosque prior to 1947. I mean, he made this very specious and foolish distinction. And on the basis of that observation, he refused to stay that suit. He refused to nip this mischief in the bud. If he had nipped this mischief in the bud, he was the author of the judgment where he had said, in that Ayodhya case, that the Places of Worship Act will prevent any such future problem from arising. And therefore he knew full well the mischief that was being done. He knew full well that this went against the Places of Worship Act. But unfortunately, by making this bogus distinction, after all, if you can't convert that place of worship, where is the question of an academic study by the Archaeological Survey of India to find out for what purpose? To find out whether there was a temple earlier there or below that, whether there are any signs of a temple. So he, obviously under pressure from the government, he refused to stay that suit, and that, as you were told, opened the doors to several other suits being filed in place after place, including Sambal. In many places across the country, although earlier VHP etc. had said we will restrict, RSS had said, we will restrict our claim to only 3 mosques: Ayodhya, Banaras and Mathura. But now suddenly, all over the country suits began to be filed. Then the validity, the constitutional validity of the Places of Worship Act itself had been challenged by some of these Hindutva BJP people in the Supreme Court. And that challenge was pending. When all these suits started coming up, some other person, secular person, filed a petition saying that the Places of Worship Act should be implemented, and all these suits which are being filed across the country for seeking, laying claim on a mosque on the ground that there was a temple there hundreds of years ago, all those suits should be stopped. So fortunately, this time around, these cases were listed together, the challenge to the Places of Worship Act as well as another petition seeking implementation of the Places of Worship Act. It came up before the present Chief Justice, and fortunately he has, for the time being at least, stayed the proceedings in any such suit which is filed anywhere in the country. He has said that such suits should not proceed any further. If they are filed, they should stay where they are, and they shouldn't proceed any further. And for the time being at least, this problem has been nipped in the bud for the time being. But we still have to await what the Supreme Court does finally when the Supreme Court hears this matter. But one thing that we are seeing is that all these movements which are taking place and the suits which are being filed, etc., all have the active support of the central government, the BJP, which rules the central government, which controls the central government, and also state governments which are ruled by the BJP. In every place we are seeing that both in the movement as well as in the proceedings of the suits, the governments are playing an active role in promoting all this. And this raises another question. In a secular country, under a secular constitution, and secularism has been held to be a basic feature of our constitution, how can the governments directly promote religious activity or religious movements? We are seeing this spectacle across the country. The government is promoting, today it is promoting this Mahakumbh, spending hundreds and thousands of crores on Mahakumbh. It is promoting the Char Dham Yatras, spending hundreds and thousands of crores to promote the Char Dham Yatras. It is promoting trips. Of course, the Aam Aadmi Party also said that we will provide free rides to people going to Ayodhya. It's not just the BJP. But we are finding that the governments are actively promoting, for example, this Kavad Yatra. I mean, where is the question of the government making tents, food arrangements, closing highways in order to facilitate the Kavad Yatra? These are religious activities, and a secular government and in a secular country run by a secular constitution has no business to be involving itself in promoting religion, any religion for that matter. Religion is a matter which is a personal matter which should be left to the people and various groups and organizations of that religion. The other issue is, what is the basis for a community claiming? I mean, I can understand somebody who owns some property or who owned a property and who's claiming that, look, I used to own this property and I was forcibly dispossessed from this property and somebody else has come to occupy that property. I can understand such a claim. But what is the basis of a claim of somebody who claims to be a religious organization or a member of some religious community saying that, look, earlier there was a place of worship which was ostensibly owned and run by people of my community. In my view, there is no such basis of making a claim on the basis of religious communities. There is no legal basis of making a claim on the basis of religious communities. But unfortunately, these kind of claims are being allowed in various courts across the country. And lastly, I want to say, why is it that these courts have started behaving like this? If you want to understand why the judiciary in India has become amenable to government influence, today it is really, unfortunately, what we are seeing is that large sections of our judiciary, particularly the lower judiciary, the lower courts and even the high courts, not to that extent the Supreme Court, but to some extent the Supreme Court also, have come under the influence of the government. The judiciary was supposed to be completely free of the government. It was supposed to be an independent institution, and one of its main jobs is to ensure that fundamental rights are protected, and fundamental rights are protected against the government. Means that the government should not assault the fundamental rights of the people. Mainly it's a protection against the government. Similarly, one other job of the judiciary is to see that the executive and the legislature function within the bounds of their powers laid down by the constitution. And for this, the judiciary needs to be independent of the government. But what we are seeing in recent years, particularly since the Modi years, in the last 10 years in particular, that the judiciary appears to have lost its independence to a substantial extent. And we are seeing this across the country. We are seeing this in a large number of judgments which are coming from lower courts, high courts, and even the Supreme Court to some extent. And the reason is, there are actually 3 or 4 reasons for this. You see, when there is a strong fascist government like it was during the emergency, many judges who do not have that very strong backbone, they get intimidated by a strong fascist government. They get fearful of a strong fascist government, and therefore they are fearful of giving any judgment which is not liked by that strong fascist government. And as I said, this happened even during the emergency, and we are seeing this happening because after a long time we have this kind of strong and fascist government, a party which enjoys a majority. Of course, today they don't enjoy a majority on their own, but today also unfortunately they are using the ED and all these agencies, ED, IT, CBI, etc., to intimidate even their allies like Nitish Kumar in Bihar or that Chandrababu Naidu, etc. And therefore it still gives the appearance of a strong and fascist government despite the fact that they don't themselves enjoy a majority. So this is one reason. The other reason is what Arun Jaitley once said in Parliament. He said that giving post-retirement jobs to judges influences their pre-retirement judgments. This is true to a very large extent. And all these judges like Gogoi got Raj Sabha membership, that Nazir, who was also one of the judges in the Ayodhya judgment, he was made a governor. We don't know what Justice Chandrachud may get or may not get. That man, what was his name? Arun Mishra. क्या हो गया? Arun Mishra, who gave so many judgments in favor of the government, never gave a judgment against the government, benefited Adani by tens of thousands of crores through his judgment. He was made chairman of the National Human Rights Commission, where he just twiddled his thumbs for 3 years before he retired. So, this is a second problem. The third problem is that this government has figured out a way of frustrating and preventing the appointment of independent judges. And this they are doing despite the fact that the Supreme Court has laid down that the selection of judges will be made by 5 senior judges of the Supreme Court, and all that the government can do is to return that recommendation once if they don't agree with that. Thereafter, if the collegium of the 5 senior members of the Supreme Court unanimously reiterate that recommendation, the government has no option but to appoint them. But what this government has been doing is, when a recommendation of an independent judge is made by the collegium, whom they don't like, they only want 2 kinds of judges. Either those who are ideologically saffron or allied to the BJP in one way or the other, or those who are weak or corrupt and blackmailable. These are the only 2 kinds of judges that this government wants. If the collegium recommends an honest and independent and strong judge, the government either sits on that recommendation, doesn't do anything. It doesn't appoint, it doesn't send back the recommendation either. Or if they are forced to respond to the recommendation, by the Chief Justice repeatedly pushing the government. They sometimes return the recommendation saying that no, we don't want this person. If even thereafter, as has happened in dozens of cases, the collegium unanimously reiterates that recommendation, even then the government has not been appointing, and there have been dozens of cases where the government has sat on those recommendations for years altogether, even after unanimous reiteration of appointment. And the last method that they have adopted is even more sinister. They have asked all the agencies, ED, IT, CBI, to prepare dossiers on all judges. High Court, Supreme Court, everywhere. If they find any weakness in any judge on the basis of which they can blackmail that judge, they use that weakness to blackmail that judge. And unfortunately, this also appears to be working with a number of judges, because unfortunately there are several judges who have skeletons in their cupboard. And if the government is able to discover that skeleton, then they use that skeleton to blackmail them. And therefore, we are seeing this problem where the judiciary has to a substantial extent lost its independence. And of course, the judiciary does pay attention to public opinion. I have seen that. And the way for citizens to deal with that is for citizens to remain awake to what is happening, what the judiciary is doing, praise any good judgment coming out of the Supreme Court, and strongly criticize any bad judgment coming out of the Supreme Court or High Courts, etc. Because that pressure of public opinion works in order to keep the judiciary on the right track. So I'll just end here and I'll hand it over to my friend.
Thank you so much, Prashant ji, and thank you, Aisa, for inviting me. It is a privilege to sit here with all of you and talk with Prashant ji on this topic. My thesis for my master's was on this topic, related, not exactly, but it was on the Hindutva movement in terms of an organized legal movement to convert places of worship, primarily of Muslim places of worship, but a few Christian places of worship as well. That was my, and its effect on rule of law, by and large. And a few things